and welcome to a newsflash episode of Unpacking the Case, the podcast by David Jones Bold, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape.
Hello and welcome to Unpacking the Case, the podcast where we break down the latest legal developments affecting the real estate sector. In today's episode, we're doing something a little different. Following our recent webinar giving an update on changes to the Landlord and Tenant Act 1954 and the government's proposed ban on upwards-only rent reviews, we received a huge number of questions from property professionals across the industry. It seems this topic has struck quite a chord, and it's easy to see why. Few proposals have the potential to reshape commercial leasing quite like the changes to rent review provisions. We've handed our audience questions over to our head of legal training, Richard Snape, and in this special Q&A episode, Richard tackles the issues that are on everyone's minds, from lease renewals, break clauses and Section 25 notices, through to the finer points of index-linked reviews, turnover rents and what the future could look like. Whether you're advising on leases every day or simply trying to understand what these developments could mean for your business, hopefully we'll answer at least a few of your questions. Let's get into it. Hi, Richard.
Hello, Lizzie.
Hello. We are here to do a podcast going through all of the questions we didn't have time to answer on our recent webinar on the Landlord and Tenant Act, including banning upward-only rent reviews. So just starting off around the 1954 Landlord and Tenant Act, someone asking, if I renew now before this legislation, does the upward-only rent review still stand?
Yeah, I mean, with the sort of the retrospective provisos, which I'm sure we'll come back to, anything that happens before implementation of the legislation can still have an upward-only rent review. And that won't change suddenly the legislation comes into force. Mm-hmm.
And is it only leases agreed after the 17th of March 2026, but before implementation, that might be caught for renewed terms?
No, the March the 17th was introduced in the House of Lords in the latter stages through its passage through Parliament as a kind of anti-avoidance provision. That's most obvious. It's where you've got a tenancy renewal arrangement that was created from March the 17th this year onwards. Then when the legislation comes into force and you exercise the tenancy renewal arrangement, then it'll have to have, if it's got a rent review, an upward-only rent review won't be allowed. It'll have to be upward and downward. And the most obvious example, although it's not the only one, is an option. So if it's an option to renew the lease created from March the 17th onwards, and the option is exercised after the implementation, whenever that might be, then the option, if it includes a rent review, will have to be upward and downward.
Thank you. And will granting an agreement for lease post the 17th of March 2026 to an existing tenant count as renewal arrangements?
Yeah, that's probably a tenancy renewal arrangement. If it's to an existing tenant, an agreement to lease. Agreements to lease entered into prior to implementation won't be subject to the upward and downward rent review, but that's probably a tenancy renewal arrangement. So that will, when it gets implemented, post-implementation, when you go into the actual lease itself, it'll be within the legislation. I'm just thinking of something, actually. I'm thinking of your favourite and mine, Colin the Caterpillar.
Yep. What are you thinking about it?
No, I'm thinking that Section 28 basically says if you've got an agreement between the parties, existing parties, to enter into another lease, then it'll be outside the 54 Act won't apply, and therefore, in those circumstances, then if the 54 Act doesn't apply, then it's a way out, and it wouldn't have an upward and downward rent review. So yeah, there's a potential little way out of it by that. An agreement that comes within Section 28 of the Landlord and Tenant Act 1954 will be outside the Act when you go through the process of renewing. It's an option, as Colin the Caterpillar cakes established.
Okay, moving on to break clauses and notices. When must a landlord serve both a break notice and a hostile Section 25 notice?
Well, I mean, if the landlord's got a landlord-only break, a redevelopment break, let's say, and you exercise the break, then all you do, if it's a 54-hour lease, is bring about the continuation tenancy, and you'll have to serve a Section 25 notice. Most obviously, on my example on ground, opposing a new lease on ground F, to actually terminate the lease. However, there was a case, there's a couple of cases. Well, there's a case called Bleachers and Dyers Association leases that said that, but there was a case, Clifton Slimline, Scholl Manufacturing and Clifton Slimline, that said you don't have to serve two notices, because if you break notices between 6 and 12 months duration, your Section 25 notice can also be your break notice. So there's no need for both notices. One will serve the purpose of the other.
And I think you've answered the next question, which is, can a landlord serve Section 25 after serving a break notice?
Well, they can serve at the same time because they'd be one and the same, but yeah, they can. Mm-hmm.
And just on those ground break clauses based on ground F, does intention need to be the current landlord's, or could a future landlord's redevelopment suffice?
I've seen loads of people fall into the trap, actually. It's supposed to be the landlord who intends to develop and not to transfer on to some developer who's going to do it for you. But there's been a couple of cases, including one, I think, from 2018, Santander and LCP, where they said that if it's a long building lease, that the landlord grants in favour of whoever's going to be doing the development, then they'll be acting as your agent. And there was a case, nothing to do, not particularly updating, but Turner and Wandsworth Borough Council, where they intended to, it was a city farm, and they intended to grant a lease to a neighbouring school, did Wandsworth, and they were going to tarmac over, knock down and tarmac over the city farm and have it as car parking for the school, for the children of Wandsworth and South London to park their hot hatches. And they were held to be, agents in those circumstances, a short 54 Act excluded lease. And then when the market picks up 4 years from now, you can terminate the excluded lease. So not normally, unless you can show an agency.
Thank you. And then just moving on to renewal terms and valuation, when is the valuation date for the court to decide the new rent? Notice date or court date?
And obviously you can decide outside court, but if it's imposed by the court, it's actually the date the old lease comes to an end, which is 3 months plus an appeal period after the court hearing. But what happens in practice is that once the terms are decided, then the last thing to decide is the rent. It's pointless deciding the rent if you don't know the terms. So it tends to be right at the end of the court proceedings, but strictly speaking, it's when the old lease comes to an end, which is not like normal rent review, which tends to be backdated.
Okay, and can a landlord impose service charge or rent review on renewal where the original lease had none?
It's so May and City of London Real Property Company and House of Lords case, which interpreted Section 35 of the Act, which says that you're supposed to have regard to the terms of the current tenancy. It's a strong burden if you want to change the terms. It's the person watching to change the terms. It's got to be fair and reasonable between the parties, and it's a very, very strong burden. May and the City of London Real Property Company itself was trying to change terms on a 54 Act renewal to include full repair and insurance obligations in return for a slightly reduced rental, and they failed. There was a case, Edwards and Walkden and the Mayor of London, about Smithfield Market, where they did succeed in standardising things like service charges between the various units. But that's probably more, Lizzie, to do with the Metropolitan Meat and Poultry Market Act of 1862.
Does a head lessee benefit from 1954 Act protection if they grant licences to residential occupiers but occupy ancillary space?
Yes, bizarrely, it might be in their best interest to actually argue otherwise. I mean, the Grayson and P&O, which basically said that it's almost certainly the case that the subtenant is the person in occupation for the benefit of the Act, although that's been rewritten in relation to upward and downward rent reviews, and that the head lessee will also be subject to upward and downward rent reviews. But with that proviso, just retaining common parts and the likes is not a business, and so it's not enough. However, there was a case called Smith and Tighten and also more recently Annington and the Secretary of State. If you don't come within the 54 Act, then you might be able to enfranchise the block under the 67 Leasehold Reform Act on the cheap. Because normally there's a residence requirement if you come within the 54 Act and companies can't be resident. So it might actually be in the landlord's best interests to show otherwise.
Are common law tenancies within the provisions?
Assuming, because common law tenancies are sort of not non-statutory, if you like, tenancies. So if you don't come within the 54 Act, excluding the Act, if you come within the definition, but the Act's been excluded, then there's not going to be an upward and downward compulsory rent review. I think that's what they mean.
Excellent. And then there were lots of questions about timing and commencement of the ban. So just to clarify, what date does the ban come into force?
We don't know. In the impact statement, when this was published a year ago and introduced into Parliament, they were saying 2027, 28. I suspect more the latter, because they've got to go through consultation and produce guidance and also consult on what they're going to do about rent collars, which I know you want to come into on that one, Lizzie.
And just on dates as well, what happened to the date of 17th of March? I've just looked it up. It was actually St. Patrick's Day this year, if they want to know that. It was also Corned Beef and Cabbage Day, apparently, on the national calendar. So there's a way to remember that day.
And it's Bastille Day today.
There we go.
And it's St. Swithin's Day tomorrow, but it doesn't look like it's going to rain. The 17th of March is when they introduced this idea of a tenancy renewal arrangement, if it's introduced from 17th of March onwards, like an option, which gets exercised afterwards, after the implementation of legislation. That's going to be subject to an upward and downward rent review if it's got a rent review. There'll be initial rent and any subsequent rent review as well.
And do lease renewals from March 2026 need to remove the upwards only rent review immediately or just over time?
No, I mean, again, March 2026 is not the commencement date. It's just if you enter into an option or any other renewal arrangement between the landlord and tenant. So no, is the answer to that. And even when the legislation's come into force, you can still include an upward only rent review. It's just that it won't be of any worth. It's got to be upward and downward. It doesn't render the whole thing void. And
just a few questions on the retrospective impact. If a reversionary lease is put in place now with upwards only rent review before legislation, will it be retrospectively affected?
No, because a reversionary lease, unlike an option, a reversionary lease, you've actually got a lease today. You're granted the lease today. You're just not allowed you can't go into possession until a later stage. So a reversionary leases might be one way of going around it.
Is an upwards only lease granted now enforceable once the ban comes into force?
Yeah, unless it's included within a tenancy renewal arrangement. But yeah, basically.
And does surrender and re-grant before the Act come into force preserve?
Yeah, surrender and re-grant is basically a new lease. So if it happened after the legislation came into force, it will be subject to upward and downward rent reviews, but not if it happens before the legislation comes into force.
And again, just more questions on the scope of the ban. Are both included and excluded leases covered?
Yeah, as long as they come within the definition of Section 23 of the Landlord and Tenant Act, you occupy under a lease at least partly for business purposes. Excluded leases come within the Act. They've just been excluded by serving warning notices, but they'll be subject to the upward and downward rent review.
And what about agreements for lease? Are they captured?
Agreements for lease. If you enter into an agreement for lease, for a brand new lease today, then when the actual lease is granted, then it can still have a sort of an up and only rent review. If it's an agreement for lease, I think we've answered this before, but between, during the currency of the existing tenancy, then it'll probably fall foul of the tenancy renewal agreements.
And are under leases caught if the head lease is not?
The head lease, because of changes in the legislation in its passage through Parliament, through the House of Commons last year, actually, they had to change it because, as we mentioned previously, to come within the 54 Act, normally you have to be an occupation. And Grayson and P&O in 1996, the House of Lords case, said that only one person can be an occupation, and that's usually going to be the subtenant. There can be exceptions. We mentioned that Gunmakers Arms case. If you remember Star Pub's quite recent case, which is all about ground G and occupation for your own purposes, which said that where you retain control over finances and things, then it's a bit different. But they changed it in terms of upward and downward rent reviews, in that all you need is a potential for occupation. So the head lessee will not come within the security in the 54 Act, but they can still be subject to an upward and downward rent review, compulsory rent review.
And does the legislation differentiate between options to renew and reversionary leases?
I think we've answered that. Basically, a reversionary lease comes into effect today, the day it's entered into. So even if it's exercised after the changes, then it can still have an upward only rent review, whereas an option comes within the anti-avoidance provisions.
And just on our favourite thing, contracting out, can the legislation be contracted out, like security of tenure?
No, there's quite stringent anti-avoidance provisions.
Okie dokie. Moving on to some of the rent review mechanics under the ban, and index-linked reviews in particular. Does RPI and CPI count as fixed rent?
I'd be a very rich person if it did. But no, RPI will come within the ban, CPI. Although over a period of time, it might just dip for a month or two, but over a period of time, RPI, or Consumer Prices Index, tends to rise. And so it's probably a much better bet in the future than an open market rent review.
And can you have rent review to higher of RPI, CPI or market rent?
The government's going to consult on that and produce guidance, because it's not 100% clear in the legislation. Again, we're going to have regulations, but they are suggesting at the moment that you can. So I think what landlords are going to be trying to go for would be the higher of the market rent and RPI, CPI. You couldn't have the higher of the passing rent. You've got to have in RPI. You've got to have the ability for rents to fall.
And what about RPI plus 5%? Would that be acceptable?
Again, it's not made clear in the legislation as at the moment. Presumably the government's guidance, which tends to be non-statutory, might just make that clear. But as long as there's an allowance for a downward rent in what would be an incredibly strange market, I can't see why it shouldn't be.
And can you put a collar on CPI?
Do you want to answer that, Lizzie? Because I know you.
I've got zero expertise on the subject.
Well, you knew what an AFL was earlier.
I've picked up a few bits in the last 6 years, but I'll leave it to you as the expert. They're
gonna consult, and they haven't started yet, on what to do about rent collars, because on the face of it, they come within the ban on upwards only rent reviews, but they may introduce some sort of exceptions, but we don't really know. If there's a corresponding rent cap, I suspect, then they might have something.
Are RPI, CPI reviews classed as upwards only?
Well, it's not whether they're classed as upwards only, although in practice they tend to be. It's that they will have to have the ability to go down if that's what the market dictates.
What about property index-linked clauses instead of CPI?
Any kind of index linking will come within it. You'd have to be subject to upward and downward.
And what about turnover rents? How does upwards only rent review relate to that?
Well, it'll have to be upward and downward. If it's a turnover rent, it's not fixed at the beginning of the lease. You don't know what it is in advance, so it's going to be subject to an upward and downward rent review.
I think you've just answered the next question, which is, can turnover have a fixed minimum that rises?
Well, no, that would be like a collar.
And then some questions about stepped rents as well. What about stepped up rent fixed for each subsequent year?
Well, that's you know in advance when the tenancies agreement's entered into what the increases are going to be, so they'll be legitimate. They won't come within the ban.
So could landlords use stepped rents to protect long-term rent levels?
They can. I mean, whether tenants agree to a stepped increase is another matter. It's actually a lot easier to deal with than sort of, open market rent review and having independent experts and the likes in arbitration to decide it. But it depends on market forces. But yeah.
Next question, can you pre-agree a higher rent?
No, once the legislation comes in, it'll have to be subject to upward and downward, no matter what you've said. And if you've pre-agreed, that would be, it's still going to be subject if the lease itself or the agreement for lease was entered into from whenever the legislation comes into force. It'll have to have an upward and downward rent review.
What happens if a rent review clause doesn't comply, implied up, down, or void?
It's still in existence. It's just that it must be subject to upward and downward rent review. It doesn't suddenly render the whole of the rent review clause void.
Okay, that's all the questions. Thank you very much, Richard.
My pleasure, Lizzie. And but that will be returning to the subject of upward and downward rent reviews over the next couple of years, if not longer. I think the other thing that people haven't particularly asked about is that one way of avoiding upward and downward rent reviews is have short leases that don't have rent reviews in them, which is what the majority of high street retail has anyway. I suspect they're going to have even more so. And tenants want shorter leases. They don't want to be stuck, as they found out during the financial crisis of 2008-9 and lockdowns. So I think that's the other possibility.
Absolutely. Okay, thank you very much, Richard.
My pleasure as always, Lizzie.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.